I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go.
oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting.
You're recanting what?
What I just stated.
Which part?
The part that I lost my spot. Oh,
well, no, it doesn't work that way.
Okay, I'm not really understanding, but I am nervous, quite nervous.
This case involves a woman accused of using fake legal arguments to hold onto $1 million home. She refuses to leave. In court, the plaintiff's attorney lays out how unrealistic and unsupported her claims really are. She leans on the familiar sovereign citizen style of argument, full of confusing legal phrases that carry no actual meaning, and the evidence clearly points to deliberate deception. What's striking is how confidently she appears in court, despite her position being incredibly weak. Some states offer limited rights to squatters, but this situation goes well beyond that. It's not simply about staying in a property. It's about using false documents and legal jargon to cover up wrongdoing. So it raises an important question. Should the law be tougher to stop people from exploiting loopholes like this before it gets this far?
Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the Federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
there's more. Go ahead.
There's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
This case is a textbook example of fraud, and the way she tried to pull it off says everything. From what it appears, she pretended to be the Whitlows, took out a mortgage on $1 million home, failed to pay it back, and then tried to use bankruptcy laws to keep the property, even though she had no legal tie to it. The problem is simple. Her name was never on the mortgage. It's like crashing someone else's car and then trying to claim the insurance under their name. It makes no sense that what's truly surprising is that she seemed to believe no one would catch on. Mortgage and bankruptcy filings are public and detailed, so once investigators reviewed the paperwork, the faucet stood out immediately. Judges focus on proof of ownership, not clever legal talk, and she has none. Her entire defense is built on misleading claims and confusing paperwork meant to cloud the facts. At this point, it's unclear whether she understands how serious this is or if she's just ignoring reality. But if she keeps going down this road, legal consequences are almost certain.
I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow,
you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that that I stated that I'm not, oh, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment. Oh,
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well, and
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
What she's attempting is one of the most common tactics used in bankruptcy fraud, and it's surprising she doesn't realize how easy it is to spot. When someone files for bankruptcy, it triggers what's known as an asterisk automatic stay asterisk, which temporarily freezes debt collection. That means creditors can't evict, repossess property, or collect payments until the court reviews the case. People who know they don't actually qualify sometimes file just to stall for time, hoping the judge won't notice that the claim isn't legitimate. But this doesn't solve the issue. It only delays it. Courts see this kind of move all the time, and once they catch it, the consequences are serious. She might have bought herself a little time, but she's risking major legal penalties in return. It's a gamble that almost never works, and it usually ends up making things much worse. The question now is whether she really believed this plan would succeed, or if she was simply too desperate to stop herself from trying.
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case, and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows, because that's the only person you have a contract with, allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what, if the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you.
I know, you didn't write anything.
We'll await. I did.
Oh,
No.
no, I don't think so.
The fact that she walked out instead of challenging the judge's order really says a lot. It's possible she realized how weak her case was and didn't want to dig herself in deeper. Something about this situation feels off. It's clearly not just a simple squatter case. There's a mix of entitlement and deception here that goes far beyond someone overstaying their welcome. What really stood out was a comment about $15,000 a month being too much, as if she were negotiating rent instead of answering to a judge. It shows how detached from reality she seems to be. The truth is, people who use loopholes like this end up clogging the legal system, wasting time and resources while staying in homes they don't own. It's frustrating to watch, especially when accountability seems slow to catch up. At some point, the patience runs out, and legal consequences become unavoidable. What do you think? Should cases like this lead to criminal charges, or should the focus just be on getting her out and moving forward?